All right, good afternoon, everyone. So happy to see so many of you before attending the session today. Hope you are enjoying the RIC this year. A lot of familiar faces, a lot of attendees, which is really healthy for us and for our organization. Before I start, I have a few housekeeping items to cover. This may have sounded a little bit repetitive for those of you who've been here for the last couple of days, but I'm obligated to walk through them just all the same. The Wi-Fi code for attendees is RIC 2025, RIC 2025. Please remember to silence your cell phones and electronic devices, and all these sessions are being video recorded. There is a QR code for your questions and answers if we have time at the end. The portion that will be done through electronic means for both the virtual and in-person attendees. For those of you in the session room, please take a moment to scan the QR code when it comes up, and you can access that code through your mobile device. I think that's up. Yeah, there you go. For those of you joining remotely, you'll find there's a box at the right of your screen with tabs for electronic Q's and A's and live polling and feedback, so all of those three items. Questions from in-person and virtual participants flow into the same queue, so the questions received represent the total session audience. We will have live polling during the session, as I mentioned a few seconds ago. For those of you in the room, the slide showing the poll will include instructions for participants to text their responses. In-person participants will text the code next to their choice of 22333. For those of you participating virtually, once you've logged onto the virtual conference platform and joined the session, there is a tab for live polling questions. Responses from in-person and virtual participants flow into the same queue, so we'll be able to see the results of those live polling questions as they come through. They are called live polling for a reason. And finally, a third QR code, probably too many QR codes, a third QR code at the very end as we close the session. You're invited to scan for feedback, provide us feedback, and share any thoughts and insights you have pertaining to the session or the conference in general. For in-person attendees, if applicable, you have follow-on questions. We have a tendency to linger afterwards out in the lobby. If you want to talk to any of the panelists, you want to grab me, we're welcome to chat with you after the session. We do ask that you exit from the room so they can set up for the next session. We appreciate it. I have one other item. Apparently, the session next door is on emergency response, and they are going to do a demonstration of their alarm. It is not for us or for the building, so if you hear something towards the end of the session, it's just part of their presentation, and you can ignore that. But I didn't want anyone to be alarmed if they heard something from next door. So with that in mind, thank you again for attending our session, Implementing the Blueprint for Modernizing Environmental Reviews in the ADVANCE Act. I have a few remarks to kind of set the stage for the session. I should note we had over 700 people register for the session, so not all of them are here, obviously, but having 700 registered participants is really a high indication of the importance of the environmental review function the NRC performs in our regulation of civilian nuclear energy and materials technology. The passing of the Fiscal Responsibilities Act of 2023 amended NEPA in the most significant way since it was signed into law in 1970. We hadn't really seen anything like that ever. Couple this with the ADVANCE Act that was passed last year, really has created a watershed moment for our environmental reviews. Big changes. Efficiency, timeliness, and predictability is the name of the game. In response to the ADVANCE Act, Section 506, the NRC sent a report to Congress in January of this year, delineating 22 of the efficiency measures in the area of the environmental review. We are heavily focused on the return on investment when pursuing efficiencies, balanced, of course, against our need for appropriate amount of tribal, stakeholder, and public participation in our regulatory processes. With this in mind, I'd like to highlight a recent success that has been implemented, being the Licensed Renewal Generic Environmental Impact Statement, and soon the new reactor Generic Environmental Impact Statement, which will yield significant benefits as well. In addition to the Section 506 report, we are also assessing brownfield use per Section 206 of the ADVANCE Act, and where efficiencies may be gained relative to our environmental reviews there. I'll keep my remarks short, and I may sound like I'm going on, but there's one last point I'd like to make, and that is to emphasize we already have in place and are implementing a process to assess on a case-by-case basis the viability of developing an environmental assessment instead of the more lengthy and costly environmental impact statement where feasible. If we believe we can reach a finding of no significant impact, we can consider this path forward while pursuing any necessary exemptions from our regulatory requirements as they exist today. We're already applying this process and have been since last year. So in sum, we're proceeding with a number of actions and are already implementing substantial changes to improve efficiency and timeliness and predictability of our environmental reviews, and some of which we're about to talk about in a few minutes. So with that, let me introduce our panelists today. First, we have Martin O'Neill. Martin is Associate General Counsel at the Nuclear Energy Institute. In this role, he advises NEI and assists NEI members on legal, regulatory, legislative, and policy issues affecting the nuclear energy industry, with a focus on advanced reactor licensing, reactor license renewal, the nuclear fuel cycle, and environmental matters. Martin has over 23 years of experience as a nuclear regulatory attorney, including 2 years with the NRC in the Honor Law Graduate Program. Sorry, we lost you, Marty. Before joining NEI in February of 2020, Martin was office counsel in the Energy of Practice Group at Morgan Lewis, where he frequently represented clients in licensing proceedings and administrative litigation before the NRC. He holds a BA in geology from Colgate University and a JD from the University of Texas School of Law, where he focused his studies on environmental and administrative law. Thanks for joining us, Marty. Next is Lisa Williams. Lisa is the Operations, Licensing, and Environmental Manager for Nuclear Development at Energy Northwest. She has over 30 years of commercial nuclear power experience and has worked at Energy Northwest for 20 years. At Columbia Generating Station, Lisa earned a senior reactor operator license and has held management positions in several areas, including operations, regulatory affairs, and reactor fuels engineering. Additionally, Lisa supported the construction of the Urenco Enrichment Facility in New Mexico and has held positions in reactor engineering, system engineering, and design engineering. Lisa has also served as chair of the Boiling Water Reactor Owners Group Licensing Committee and represented the BWR fleet on the Technical Specification Task Force. She holds a BS in nuclear engineering. And I would like to commend Lisa because we called her no less than, I think, 3 weeks ago and said, can you please sit on our panel, because we had someone else drop out. So Lisa, thank you very much for joining us. Next up is Nico McMurray. Nico leads the development and execution of ClearPath's international nuclear policy portfolios to advance the organization's mission and vision. Nico has expanded ClearPath's nuclear energy technical and regulatory depth, allowing the organization to be a strong resource for members of Congress and other partners. Nico serves as a member of the Keystone Energy Board, represents ClearPath before multiple other industry groups. Before joining ClearPath, Nico was a materials engineer at the NRC, where he developed technical guidance on materials, component integrity, and licensing topics for new and advanced nuclear reactors. He holds a BS in materials science and engineering from The Ohio State University. Thank you for joining us, Nico. We have Alicia Williamson. Alicia is a senior environmental manager at the Loan Programs Office within the U.S. Department of Energy. With over 20 years of experience in the environmental compliance and radiation protection, she has been with DOE for the last 5 years. Prior to this, Ms. Williamson worked 16 years at the NRC, specializing in environmental compliance with the National Environmental Policy Act for licensing new reactors and license renewal. And she holds a BS in biology and chemistry and an MS in environmental science. Welcome, Alicia. I should mention also Alicia was a last-minute addition to replace one of her colleagues who was unable to travel. So, Alicia, thank you very much for willing to step in. And finally, Ted Smith. Ted is currently the chief of the Environmental Technical Review Branch 2 at the Nuclear Regulatory Commission, where he oversees scientific and technical reviews of environmental reports for the NRC licensing actions. Prior to joining the Environmental Center of Expertise as a branch chief, Mr. Smith was a project manager in the reactor decommissioning branch of the Division of Decommissioning, Uranium and Recovery and Waste Programs. Before joining the NRC, Mr. Smith worked as a consultant supporting DOE's Office of Environmental Management and also served at the Naval Nuclear Propulsion Program headquarters. Ted holds a BS in electrical engineering and an MS in environmental engineering. Thanks for joining the panel, Ted. Appreciate it. All right, with that, welcome and thank you all for joining us today. And let's get started, and I have 2 opening questions for you to consider. All right, is my mic live? You all hear me okay? Okay, good. Before we get started, I have these 2 questions, and then I think we're going to go to a live polling question. Think about this while we poll. For each of you, could you please briefly describe your role within your organization and how this fits within the larger NEPA context? Also, please share your why in addition to why now for your interest in being on this panel, apart from being called at the last minute, of course. But secondly, and I mentioned FRA and the ADVANCE Act, these 2 acts have placed an increased emphasis on efficiency. I mentioned the Section 506 report, which required the NRC to report on the efforts of the Commission to facilitate efficient, timely, and predictable environmental reviews. This was under Section 103 of the Atomic Energy Act of 1954. It included expanded use of categorical exclusions, environmental assessments, generic environmental impact statements, et cetera. And I think we're curious to hear your thoughts on what efficiency means to you in this context. For example, do you believe the main intention is to be swift with respect to schedules, to be more efficient with respect to hours charged to each action, or are there other nuances to consider? So with that, while you are thinking deeply, I'd like to take our first live poll. So if there's production, could you put up the first poll? There we go. Okay, so which of the following ongoing efficiency, timeliness, and predictability efforts for environmental reviews consistent with accelerating or the ADVANCE Act do you perceive to have the biggest potential impact? Organizational capacity changes, program process improvements like generic environmental impact statements, technology tools like an online portal, consultation process efficiencies, for example, the National Historic Preservation Act and Endangered Species Act. All right, so as we see the results come in, I think it's a very, very clear response. The majority are looking at the process improvements. So, okay, so with that, while the answers are coming in, we will keep an eye on those. Panelists, who would like to try and answer my questions first about what do you think about efficiencies in the ADVANCE Act?
I can start.
Go ahead. Thank you, Ted.
Sure. So I think efficiency means the effective use of resources, time, people, and money. It's also an opportunity for the leadership and management to make decisions about how we can be strategically smart about the application of resources and focus on the timely and predictable completion of high priority work in coordination with our safety counterparts. Efficiency also means the NRC as an agency applies the right resources to the right places to reach the quickest, fully considered licensing action possible. That means we are coordinated in our reviews, working together as one NRC to make appropriate timely decisions. Some challenges to that our workload may be less predictable in terms of the timing and quality of applications that we receive. So we need to consider how to properly engage and lean on pre-application activities to mitigate some of those uncertainties. Another challenge is for leadership and management is to make sure that we have people, give them the opportunities to cross-train and to qualify across a range of areas so that we can be more flexible to meet the changing needs as workload changes.
All right. Thanks, Ted. How about you, Nico? Would you like to comment?
Yeah, I think focusing on the efficient, the effective, and I think the word I would also choose would be predictable. So of course, efficient, you want the process to be a little bit faster. I think the effective piece is really something that we don't quite appreciate as much, where it's focusing on the right things. Like there are limited applicant resources, industry resources. There's also limited staff resources. And so you want to make sure that whatever the staff are focused on, it's actually the most important thing. I think that's where a lot of the work so far with things like the GEIS is really helpful to really kind of guide where should the staff be looking. And then of course the predictable piece, also something in the ADVANCE Act, what are the milestones, what are the outcomes? Predictability is really important for, of course, industry. Again, it's also really important for staff to know, hey, this project's done, on to the next one. And as things look to scale, it's really making sure these are all kind of aligned. Happy to also comment a little bit on our comments on 506 of the Advance Act in the letter itself. I frankly view that as one of the most important sections of the Advance Act. I also think it's really important to appreciate that that provision or that section was not in the initial Senate version, it was in the House version. And so this meant that it was recognized in both the House and the Senate in a bipartisan way as being really important. And so I think it's a really, building off the Fiscal Responsibility Act, where again, you had bipartisan interest and support to improve the NEPA process and improve the environmental review process. You saw that all in a nuclear specific way. And so I think kind of going forward, there's a lot of interconnected activities, the GEIS, the categorical exclusion rulemaking, the uncontested mandatory hearings, whatever will happen after the commission votes on the Fiscal Responsibility Act, SECI, there's a lot of interconnected efforts, and those can all have a really big impact. And so it'll be interesting how, the staff really weave that together. And I do think that the letter did a nice job of kind of capturing all this work to date.
Thanks, Tico. So I know Marty's itching to answer the question. So, Marty, if you could talk a little bit, it's why did you volunteer or accept our invitation to sit on the panel? And then maybe you can talk a little bit about the aspects of efficiency, timeliness, and predictability from the Advance Act.
Oh, sure. And first and foremost, I did want to thank you and the NRC for inviting me to be on the panel, and the audience as well. As a self-professed NEPA nerd, I'm very happy to see such interest. And just quickly, I've in my now 24 years as a regulatory attorney, NEPA has definitely been one constant and recurring theme. I think even in my first year as a lawyer, I was briefing Commissioner Merrifield on environmental obligations of the staff, including NEPA. It's come up in many of the contested hearings I've worked on over the years. But since I've joined NEI about 5 years ago, I've been the legal division lead on advanced reactor and NEPA issues. And I can say that efficient environmental review process has always been core, central to NEI's mission, something we focused heavily on. I think in the past 5 years alone, I've been involved in preparing or assisting in the preparation of, I think, more than a dozen different NEPA-related submittals to the NRC, DOE, and the Council on Environmental Quality. So a big part of what I do and what NEI does. But I think it's crucially important now, for the reasons you mentioned. With the FRA amendments to NEPA, you now have explicit timelines and page limits for EISs and environmental assessments. So obviously that's, a big driver for efficiency. Certainly very supportive of the 506 provisions in the Advance Act. They aligned with many of the recommendations that we included in a paper that we sent to the NRC back in 2020. And really no coincidence. I think, we're a policy and a lobbying organization, and we certainly provided, input to members of Congress, who were behind the Advance Act. So very supportive of those provisions. I guess I would, just add in terms of, do you want me to touch on the efficiency or?
Sure, go ahead.
Yeah, well, just from an industry perspective, I think, expeditious but still achievable schedules and reasonably certain cost are really of paramount importance. And I think the two kind of go hand in hand. And I will do a shout out to my friend Tim Williamson from Shepherd Power, who's done this a couple of times to me at panels. He was on the rapid high volume licensing panel yesterday, and I think he said it very well in the context of oil and gas interest in microreactors. They want to be certain, customers that licensing and regulatory timelines and costs fit within their capital expenditure decision-making framework. So, it's the old adage on time and on budget. So.
Very good. Thanks, Marty. Lisa, I'm going to come to you, perhaps for an additional industry perspective. You want to share your thoughts on efficiency, predictability, and timeliness in the NRC's environmental review?
Thank you. I think yes to all of the above. When I have to admit, I actually looked up what the definition of efficiency was, because I'm that kind of nerd. And it's minimizing the input to achieve a desired output. And I thought, well, what are the different inputs that we are looking to maybe take advantage of? And for us, that would be, can we rely on existing data to provide an equivalent level of information? Minimize our schedule and cost. Can we, by relying on that existing data, then eliminate some new field construction, well drilling, tower erection, can we perform activities as confirmatory during the period of construction rather than requiring them to be done prior to construction permit, to us issuing the construction permit application. And then looking for NRC to really minimize the need to redo or approve analyses that have been performed by other government agencies or your national labs. So I think all of those from an applicant perspective would really help us right size our effort and still meet the NEPA requirements.
Well, thanks, Lisa. I'm going to go to Alicia. I'm not going to let you quite off the hook. You were actually, a part and partner as one of our federal partners in implementing the ADVANCE Act. Could you talk a little bit about DOE's perspective on implementation and efficiencies resulting from the ADVANCE Act?
Sure. So first, I'd also like to say thank you to the NRC for hosting this panel on a very important and always evolving subject, environmental reviews and their modernization moving forward with NEPA. And I guess I would say from the DOE LPO perspective, we look, as you've already touched on, and some of the other panelists have sort of mentioned, the DOE LPO looks actively for partnership and collaboration with other agencies. For instance, I know, and we may get into it more later, how the DOE LPO has an MOU with the NRC. There's other elements within the department that also has their own individual MOUs with the NRC. So that's the first thing that I think the DOE does as part of our environmental review process with an LPO. We look for where can we partner with other federal agencies. And in my time at LPO, I know that we partnered with, of course, I mentioned the NRC, the FAA, the BLM, amongst others. So, as you approach reviews in that way, it allows for those other efficiencies to be gained as part of that environmental review process. When you're able to leverage expertise from other agencies, you save time in terms of staffing resources, you save time in terms of schedules, so each agency is not doing the same thing over and over again for the same project, asking and going through the same environmental review or NEPA process. So that's the first thing I would say is partnership and collaboration is what the DOE LPO initially sets out to do. Next, the other item I would bring up that we looked in order to try to gain efficiencies is we have leveraged the FRA NEPA Section 109 adoption of CADXs. That's something that the DOE's Office of NEPA Compliance has actively sought to incorporate within the various departmental elements to move forward with in order to try to leverage, other agencies' CADXs, and so we don't have to necessarily conduct those reviews on our own. So that would be my input.
Well, thank you. All right, I'm going to queue up Ted next. I have a question for you, something that I'm a little bit familiar with myself. So the Environmental Center of Expertise staff undertook an exercise to review data on timeliness as well as impact levels back to the year 2000. And really this was to gain insights on how we assess impacts for future projects and determining the appropriate level of NEPA review that we would undertake. Could you share some insights gained from this exercise that might inform future activities? And if you would like to, there was mention at the commission briefing last week, a report by the Columbia University Center on Global Energy, and this was mentioned by Dr. Huff last week at the commission briefing. Any thoughts on the recommendations in that report and also the kind of the insights and outcomes for the staff's assessment on our historical look at impacts?
Sure, Chris. When we reviewed the data on timeliness, what we found was that since the early 2000s and up until about 2019, the average length of time it took to complete a review was increasing. For example, from 2000 to 2009, the average time was 2 years. From 2010 to 2019, the average was about 4 years, excluding some outliers that had some particular issues like Indian Point. However, since 2020, we've been publishing EISs on a faster timeline, with an average time for license renewals from 2020 to 2024 being close to 21 months. Now, With the ability to leverage the license renewal guise, staff are setting review schedules for license renewals at 18 months or less. In terms of the impact levels, we found that a moderate or large conclusion was largely influenced by past land disturbance, such as river modification, combined with future development and urbanization. The impacts were generally due to past or future changes and external factors rather than incremental effects from the plant itself. For example, future transportation projects near Turkey Point were expected to impact air quality. Under aquatic resources, moderate or large impacts were related to effects on specific aquatic species, temperature changes, changing fish populations, and habitat loss or changes. In the area of historic and cultural resources, the key drivers were the presence of archaeological sites, including those listed under the National Register, a lack of formal survey, or the existence of undisturbed areas, as well as indirect visual effects like transmission lines. With regard to insights gained on how these might be applied to future projects, it would be helpful for applicants when selecting a site to consider the impacts on aquatic and terrestrial species, habitats, as well as the potential for historic properties, which might affect the significance of impacts. While NEPA allows agencies to reach FONSIs based on the beneficial effects of mitigation measures analyzed in EAs, these measures must be enforceable. NRC's approach would consider any available enforceable mitigation measures in determining whether the proposed action has significant impacts. Now, turning to the Columbia University report, the report contained 4 recommendations, all of which are already being pursued by ECOE staff or considered as policy changes to the commission. First, that we pare down 2 analytical sections of the EIS, the need for power and alternative sections. The ECOE is developing a streamlined approach for alternatives analysis and policy recommendations with regard to alternatives, which are included in SECI 240046. I would also note that since completion of the LR GEIS, license renewal NEPA reviews already exclude need for power evaluations. Second, use a generic environmental impact statement approach. Staff published the NR GEIS and proposed rule in October 2024. Staff are evaluating public comments and expect to provide the draft final package, including the supporting guidance and the GEIS, to the Commission by December 1st of this year. Third, develop EAs instead of EISs where appropriate. Chris, as you've already mentioned, the staff has implemented this on a case-by-case basis already, and we've provided recommendations associated with the level of review in our SECI 240046. And then fourth, remove the EIS requirement for every new reactor licensing from its Part 51 regulations. This is also part of the rulemaking plan in the SECI 240046.
Very good. Thanks, Ted. So now we're going to turn the tables a little bit. We'll be talking about like NRC's efficiency. And I'm going to look to my colleagues here in industry and for Marty and Lisa. So we've covered and discussed a little bit about the efficiencies that the NRC is working on. But we're interested in hearing what efficiencies in the preparation of environmental material and the lead up for the environmental review that industry has taken. Could you expand a little bit about where you think industry can take actions to improve the efficiency in the environmental review? And also maybe what your response to the prospective efficiency gains that the NRC has been communicating, and are we meeting expectations or can we do more?
Okay, I'll start on this one since Marty took the last one. And I was almost going to have to go beat Ted up because he was stealing my thunder on the first question. And some of the industry actions we're taking, I think all applicants will be taking, is to have a robust pre-application engagement with all of our stakeholders. And we have quite a few for our project site in Washington State. So obviously we have the NRC. We're on federal land that's leased from DOE Hanford. We are seeking a loan for our project from the Loan Program Office. And then Washington State has its own state version of NEPA. So we've begun outreach with all of those entities, and we've also, the NRC has also been reaching out directly to the DOE and the Washington State to get all the necessary agreements in place to allow the cooperation that Alicia was referencing. We do plan to take advantage of the NRC's LIC 116 process for performing readiness assessment prior to submitting the application, so that we make sure we have the right level of detail for y'all to be able to do a efficient acceptance review. We do want to leverage the new reactor GEIS as much as we can. We are targeting early to mid 2026 for construction permit application submittal. So we'll see how much we are able to license it, or use it, but at least we have it now and can be looking at the arguments that it's making. And then similar to what I talked about in efficiency, the site we have is very well characterized. We have a lot of data on it. So we're going to be looking to utilize as much of the information we have on the site as possible. We have existing monitoring wells, and we monitor groundwater movement. DOE monitors groundwater movement. We have Met Tower, and we're going to be looking to rely on that existing data while demonstrating the adequacy.
Very good. Thanks. Marty, would you like to comment?
Sure. Yeah, I would certainly echo some of the things that Lisa said. I think on the importance of having a really robust permitting plan in place. I think people don't realize maybe how many licenses and permits and other authorizations you need from other federal agencies, state agencies, and local entities beyond the NRC. So I think it's crucially important to start working with those entities very soon, pre-application process. We're talking about things like the Clean Water Act, dredge and fill permits, the water quality certification under 401 of the Clean Water Act is critically important because the NRC cannot and will not issue a license until that certification has been issued or waived appropriately. So a very important issue. Just on that note, I would actually encourage people to take a look at Appendix F of the draft new reactor GEIS, probably the most comprehensive discussion or overview I've seen of all the requisite permits and licenses that you need. So in terms of the pre-application process, I don't think the importance of that can be understated. It's actually not a regulatory requirement, but I think it's become a de facto requirement. I think it's critical that applicants, engage early with the NRC staff. Not only to build a collaborative relationship, with the staff to the extent possible, but to identify a lot of those key legal, technical, and policy issues that could be sources of delay down the road. And there's a number of vehicles for doing all this: regulatory engagement plans, white papers, topical reports. I think the staff, also does pre-application readiness assessments. I know that's something that I think TerraPower availed itself of. But if you look at the online, there's a lot of pre-app activities going on. I think Kairos Hermes 1 and 2 is a good example where they did identify a lot of issues, resolve a lot of things up front, and that led to very expeditious timelines, licensing timelines. I think Ted mentioned a number of things that the NRC is doing, and I think it's important that the industry really lean into that, kind of match the staff's energy and really try to take advantage of all the things, whether it's the audit process or request for confirmatory information in lieu of RAIs, all that. There's a lot of different things that applicants can make use of. And I would just encourage applicants to be bold, to think outside the box. Again, consider the possibility of EAs, through the exemption process. Look at alternative sources of site data. This may be more of a safety issue, but met data and seismic data, that kind of thing. Can you use that existing data? And I would say, NEI, and I'll mention the RIDRA paper, the Rapid High Volume Deployable Reactors and Remote Applications, quite a mouthful. We tried to be bold, and have sent those recommendations to the NRC.
Thanks, Marty. So Lisa, you had mentioned this idea of, getting out in front and talking with, well, both of you talked about, federal and state permitting and local governments. And I kind of like to talk to, ask Alicia, this whole idea of like consultation and like the external engagements. It's a key attribute of our NEPA requirements. Consultations under the umbrella of NEPA can be time-consuming. What are, from your perspective, the NRC and DOE doing to streamline consultations under the Endangered Species Act and the National Historic Preservation Act? And how do you think we can best go about leveraging, previous environmental analysis in this regard?
So for the consultation process, I would point to the example of the Palisades Restart Review, that the NRC is the lead agency and DOE is a cooperating agency on that particular environmental review. And as part of that review, what DOE, we worked with the NRC to do was to ensure that we weren't duplicating our efforts and just to make the process as efficient and effective as possible. We worked in LPO directly with the environmental staff in the Center of Environmental Excellence, as well as the project management team, to ensure that the DOE LPO's proposed action was, adequately spelled out as part of all of the consultation documents that went in front of the Fish and Wildlife Service, as well as the State Historical Preservation Office and the tribes as part of the National Historic Preservation Act, Section 106 consultation. We worked very closely and carefully to make sure that, like I said, the DOE or the LPO's action was a part of that consultation, so that we could leverage that consultation and whatever concurrences or conclusions that those agencies reached, the DOE can use them as part of and inform our decision making as part of the Palisades Restart process. So that would probably be the main example that I would give here in recent times. I think it was a very efficient process. The DOE, like I said, we were part of the letters. We sat in on many of the meetings, and we just worked closely with the NRC staff. The only other thing I think I would mention as part of the NRC LPO Memorandum of Understanding, or MOU, we left some flexibility in that MOU to allow for, depending on whatever the project was, because it wasn't necessarily a project-specific MOU, it's just for future shared nuclear energy projects. But we tried to leave flexibility in that MOU where the NRC, depending on the NRC would be the lead agency under NEPA, but for consultations, we wanted to leave some flexibility where in some instances, if it made sense for DOE to take the lead on the consultation, they could, or the DOE LPO to take the lead on that consultation, they could, or if the NRC could take the lead, so.
Again, thank you. On the subject of cooperation, right? We've heard that term mentioned. We talk about consultation, we talk about cooperation. Nico, in ClearPath's comments that you submitted on the NRC Section 506 Advance Act effort during our public engagement standpoint, you indicated the NRC should, to the extent practicable, rely on prior studies or analysis prepared by federal, state, and local government permitting agencies. You pointed to a recent example of the NRC and DOE's coordinating matters on NEPA for a reactor demonstration project supported by DOE, the Nuclear Innovation MOU. Could you talk a little bit or expand upon that example, and what aspects of this Nuclear Innovation MOU do you think really kind of represent where we might think areas for clearer and more effective policy on MOUs would be?
Yeah, thanks, Chris. I think pulled in a couple threads from previous comments, and I think even on the consultation side, kind of that next step would be, this focus on compliance of some of these other environmental laws, where like NEPA is the procedural statute, there's a lot of other environmental laws that have to be met, and so how can the lead agency and the cooperating agencies really work together to say, all right, you'll decide this, we trust you, in order to get the license faster. So I think there's a lot of good progress there, and I think that focus on more of you have to comply with the law, especially these other statutes, is really important. Going back to kind of the cooperation piece, I think, the Fiscal Responsibility Act does a really nice job of this. And I think with the Advanced Reactor Demonstration Program, looking back a bit from starting back in 2020 was the first of the major kind of 20 plus demonstrations that DOE is focused on across a wide suite of technologies. Nuclear being specific to the NRC, having kind of oversight of the goal is a commercial facility or commercial facilities. And so it really required both the DOE and the NRC to kind of think about this early. And that's kind of the impetus of this MOU. Making sure you're not duplicating resources across agencies. I would also frame it as you're not overly burdening the communities, where DOE is going in of we have to do a NEPA review just to provide the funding before the NRC even starts, the construction permit, much less operating license work. And so really thinking, critically across what is the outcome of a commercial project, and then thinking through well, do you need to do a NEPA review up front to give the money for these projects, as opposed to you're going to go through this process when you ultimately have a commercial facility. And so I think that was a really good example of NRC and DOE kind of getting ahead of a lot of these other projects. The other one I think is really interesting, and we'll see how this gets leveraged, is for the HALEU environmental impact statement that DOE put out. A lot of these new developers are interested in submitting fuel fabrication facilities. A lot of companies are looking at either building or expanding enrichment facilities. And so how the NRC leverages that environmental review work from the DOE, which looked all across the entire front end of the fuel cycle, that is another, I think, opportunity for cooperation and leveraging some work. A couple other the last piece I would think as well is when you're looking, and I think we'll talk about this a little later too, is some of the DOE authorization work for some of the earlier other demonstrations that might be happening. How can some of that work also get captured ultimately into the NRC? Of course, a lot will be site-specific, that's very true, but if you're building a reactor and it's small and you're testing it, and you're building a commercial version, it's a little bigger, but it's still small, what can also be leveraged there on the environmental impact side? And I think a lot remains to be seen, but looking ahead in this focus on cooperation, I think can really pay some dividends.
No, thanks, Nico. Any of our other panelists want to comment? Go ahead, Marty.
Yeah, I just wanted to quickly chime in, and well said by both of you. I agree there's definitely a need to avoid duplicative NEPA analyses by agencies. And I did want to encourage, I think, the NRC, in addition to making extensive use of incorporation by reference, to further explore the possibility of adoption. In fact, NEI just held a nuclear law 101 class recently, and one of the attendees asked me, what does it take to get the NRC to adopt an EIS? And I looked at the history, and typically NRC EISs have been adopted by other agencies, maybe DOE, but not the other way around. And I think another good example too, where the NRC should explore opportunities for cooperating agency status. Historically, we've done that with the Corps of Engineers. We talked about DOE, but how about somebody like TVA, where in the Clinch River site, where as a governmental or quasi-governmental entity, they're preparing their own EISs. Again, I think that's another opportunity to look at.
Yeah, thanks, Marty. Yeah. Level of review has been an area of focus for us to determine, what's the appropriate level of review for our environmental activities. 10 CFR 5120B currently requires an EIS for all new reactors, including test reactors. And the NRC would need to issue exemptions to develop an EA for new reactors. And you recall in my opening remarks, I talked about, our current process to look at all applications relative to the viability of pursuing an EA. Even if 5120 required an exemption, we would still take a look to see if that's a viable path forward. The NRC, we pursued an EA associated with the Kairos Hermes 2 construction permit, issued an exemption to allow us to proceed down that path despite or in light of the 5120B requirement to do an EIS. So, Ted, could you talk a little bit about the circumstances relevant to Hermes 2 that really provided the basis for us pursuing an EA for Hermes 2? And then maybe when Ted's given the answer, I'll offer the opportunity other panelists would like to weigh in as well. Ted?
Sure. So there were a number of circumstances with Hermes 2 that I think you're well aware of that helped with that EA decision. So it was a very similar design with the first Hermes plan. The proposed siting was within a few hundred feet of that same facility. The site was industrial and had heavy prior disturbance of the site and the land. We had just recently completed a NEPA review and published a final EIS for the first Hermes construction permit. And that permit covered the same resource areas for the Hermes 2 site. So as far as what that means for other applications, just to sort of extend what those circumstances were, in the SECI 240046, we indicated that exemptions from 5120B will be considered on a case-by-case basis with appropriate communication with the Commission. It's notable that one of the unique factors is the industrial nature and the heavy prior disturbance at the site. This could be a useful model as we think about a future licensing for next-of-a-kind similar designs at brownfield sites, especially sites that have undergone a recent environmental review by NRC or other agencies, as we talked about adoption and leveraging, where the staff can demonstrate no significant environmental impacts or have existing environmental monitoring data. In general, the EA approach may be appropriate for certain projects that will not involve substantial consumption of environmental resources, substantial environmental emissions, or disturbance of sensitive environmental resources.
Thanks, Ted. Any other thoughts from our panelists on, the NRC completed an EA for the Hermes 2? Any thoughts on the circumstances surrounding that and outcomes, impacts, et cetera? Okay, all right.
I can wait.
Yeah, okay, go ahead, Marty.
Doing all right on time?
Yeah, we're doing okay.
Yeah, well, first of all, just, definitely commend the staff for pursuing greater use of EAs, via the exemption process, just for everybody's benefit. The reg that Chris mentioned basically, creates a default. An EIS has to be prepared for essentially any reactor licensing action. So, we're definitely glad to see the staff thinking outside the box. I think in the case of Hermes 2, there was clearly a really high probability that you were going to get a finding of no significant impact, given the co-location with Unit 1 and all the work that was done. But I think that said, I still think there's good opportunities, for expanded use of EAs for other, reactors and fuel cycle facilities. And I think that's because applicants are going to make very deliberate efforts to avoid siting these facilities where they could have the types of impacts that Ted talked about earlier, on sensitive aquatic resources, ecological resources, historical resources. I think that's got to be a focus. And then obviously, brownfields are a different creature or beast altogether, but still you have, disturbances there. And then, I think all of us got to recognize that, again, I'm an industry representative, but I think nuclear is net positive, beneficial, environmental effects, and that should really play into these analyses as well.
Thanks, Marty. All right, if I could cue our production crew to go to our next live poll, and I see that it's already up there, folks answering. Excellent. So, which forward-looking activities do you think should be prioritized? Answer A, potential rulemaking activities associated with implementation of the Fiscal Responsibility Act of 2023. B, review process for former fossil fuel power sites and brownfield sites. C, regulatory framework developed for microreactors or rapid deployment high-volume reactors. And D, exploring categorical exclusions. I should add that we were limited to 4 responses because I'm sure you all probably wanted to say all of the above, but we were limited to 4. And it's actually, looking at the response, there's a couple, A and B, the rapid deployment of high-volume reactors, the microreactors, and the rulemaking regarding implementation of FRA are strong contenders. But there's a wide array. I mean, you can see there's a lot of interest in all 4 categories. So I would agree. They are all important. We do have limited resources, so we do have to focus our efforts on the highest return on investment activities, but they are all on the table. So thank you very much for your responses. Keep plugging them in there because we we are going to actually use the data from these polls to help inform our path forward. So thank you for that. All right, let's go to our next question, and this one is for Nico on CADXs. ClearPath has communicated the NRC should establish new CADXs to expedite the review process for certain types of actions related to new applications. You recently commented on the NRC's proposed rule CADXs for environmental review, stating the NRC should consider a CADX for certain Class 103 licenses, promulgate a CADX for Class 104 licenses, and allow use of mitigated CADXs in the final rule to ensure any change of no significant construction impact regarding ground disturbance is limited to previously disturbed areas. So could you elaborate on these points and the extent of your recommendations that we include or expand the use of CADXs in these areas?
Yeah, a lot in there, and happy to share the ML number with anybody afterwards of the public comment. But kind of before diving into those, I want to take a step back. There was a Fusion session yesterday, or 2 days ago, I believe, or yesterday, and a question I get on Fusion is actually, how is Fusion raising so much private capital? And the answer I always give is they are able to build, test, and iterate, and keep meeting milestone after milestone. It's a lot harder to do that for fission reactors. And it's not to say it's impossible. We've seen some examples. I mentioned Kairos, research reactor, Abilene Christian University with their research reactor, DOE, some of the work that's going on at INL and NREC at the Dome, a couple even, process heat or heat, not nuclear heat, test facilities that some developers are coming up with. So we're seeing this happen. And so if we look ahead, I think it becomes an interesting question of how can you make this easier to do? And I'll come back to that at the end as well. I also think it's important to flag that this rulemaking started before the Advance Act was enacted. And one of the provisions in the Advance Act, specifically the environmental section, says consider CADXs for Class 103 licenses. I know that's a big jump. I completely agree. We did see it on the poll. But I think it's something really interesting to think about of what would allow a certain technology on a certain site or a set of sites that would be eligible for a CADX. I think it's a really interesting question. And while maybe not relevant for this rulemaking, as it's kind of in process, and a lot of these technologies are still under development and not yet widely deployed, it does become a really interesting question for a 103 commercial reactor of what that would look like. I would also notice that in the Ridgewell paper, they even consider the idea of a general license for reactors. Probably require some legislation, but it does become very interesting, if we're really looking ahead of building, tens, 20s, hundreds of new designs, something for the staff to, think about. On the 104 research reactors, that I think, there's a lot of opportunity there, where generally a lot smaller, have a lot of operating 104 reactors in very, commercial sites or urban sites in some cases. So what that would look like, I point to in the public comment at DOE, actually, ClearPath published a paper several years ago in response to the Energy Act and the Bipartisan Infrastructure Law of, hey, DOE, you currently have a CADX for research and development activities, as well as for pilot facilities that explicitly does not allow the CADX for demonstrations. We propose that that would be an interesting thing of if you're programming the Energy Act or funded in the Bipartisan Infrastructure Law, you should probably have a CADX, so it doesn't go back to what I commented on before of kind of this dual-track NEPA process that becomes redundant. It's a little late, unfortunately, for that, but I think it's an interesting DOE CADX that could be considered by the NRC for what would be a smaller test facility. So again, something to think about there. DOE has this, again, maybe, ARDP reactors, they're commercial too big, but maybe something smaller, again, would make a lot of sense. INL actively doing a lot of this with some of their, test facilities at the lab, again, becomes some interesting examples to consider. Going to the ground disturbance comment as well, point 2 in the public comment, Bureau of Land Management published trying to make it easier to build solar on certain sites, specifically near transmission lines and, quote, previously disturbed lands. So similar language that NRC is considering. Very promising, but the framing of the comment was really focused on make sure this is not overly limiting. We don't have perfect foresight of what some of these new deployments would look like, but if you have a technology that doesn't have a significant construction impact, why would it matter if it was on previously disturbed lands? And so I think you need to think just, long term, not to create a de facto requirement that might actually limit the deployment of these technologies, even if they don't have, an impact on, environmental, lands. So something to think about there as well. And then going back to kind of why this is really important, it's important to the staff, and I think one of the biggest values to the staff is actually test facilities for test data, verifying models, construction inspection experience. And so by making it easier for industry to build and test and iterate, it will also really help the staff as they get to learn these new designs, as they verify some of their models and their work. And so it's a really unique opportunity for some of the work on the environmental side to have a direct impact on the safety review side that would ultimately help kind of going forward to really verify a lot of these things. And so, taking that bigger picture look at some of these ongoing activities can be really, really beneficial, not just in the short term, but really, in the long term as companies are looking to scale.
No, thanks, Nika. That's very helpful to understand some of the perspectives on the extent of where the use of CADX in the future could be beneficial. You mentioned, and it's actually a fairly good segue, because you talked about ground disturbance, previously disturbed locations, and one of the hot topics currently is brownfields. And I mentioned Section 206 of the Advance Act and the staff's efforts to assess potential regulatory changes to make the environmental review more efficient when it comes to brownfield or previously used locations. Lisa, could you talk a little bit about where you see potential areas to streamline the environmental reviews for brownfields or previously disturbed sites?
I sure can. I think this topic is very interesting to industry. It might not have gotten the top votes on the thing, but I think just if we step back from 1,000-foot level and say, where is the environmental impact going to be less on a site that's been already developed, used for industrial purposes, or a site that's a greenfield? I mean, we think we can all agree reusing an existing site is probably going to have a smaller environmental footprint. Now, maybe there are other aspects that need to be taken into consideration from the safety side, but just in the environmental side. And so we know the premise, too, from industry is that we know a lot about this site. We know the geology, hydrology, meteorology. It might be old information, but exactly how much and what types of new information do we need? And what is an acceptable pedigree to NRC, at least on the environmental side of the information? I think we kind of mentioned, we on our brownfield site have a very detailed map of areas that have been previously disturbed. And is there any consideration for, if I'm limiting my new construction within that footprint, what kind of benefit can I see? Also, if the site has developed processes for dealing with new information that might be discovered during activities such as cultural artifacts or an endangered species, does the site, have they implemented those processes and been using them throughout, and then can we leverage that at all? Have they been doing groundwater monitoring, and if so, do we know what is our level of knowledge with respect to the way groundwater moves through the state? So can we streamline this process to really use the data that we have and encourage these, make it easier to put something up, at least from an environmental standpoint, on a brownfield site?
Very good. Thanks, Lisa. Ted, I know that the staff has been looking at Section 206 and conducting an assessment. Do you have any thoughts on regulatory pros, cons, potential changes on the use of brownfield sites?
Yeah, and I can give a little status on where we are on 206 as well. So it is prompting us to look more closely at the extent to which modifications of our regulations, guidance, and policy is needed to enable efficient, timely, and predictable licensing reviews for covered sites, which are brownfields and retired fossil sites, or maybe a site that's both. We've hosted, under the ADVANCE Act work, 2 public meetings where we've engaged with stakeholders, including GAIN, NEI, state representatives, and we've had 1 government-to-government meeting with EPA to better understand licensing issues surrounding the covered sites. We're still preparing a report that'll be submitted to Congress on potential regulatory modifications to expedite the licensing review process for nuclear facilities at brownfield and retired fossil sites this September. We'll be following up with a second report to Congress on how we've implemented strategies to achieve predictable licensing reviews and oversight in July of 2027 in accordance with the ADVANCE Act.
Thanks, Ted. All right, let's shift gears a little bit and take a little bit, hop in our time machine here and mention renewals. We had a number of early site permits that were issued back in the early 2000s and early 2010s, which were valid for anywhere from 10 to 20 years. Well, fast forward 10 or 20 years and we are where we are today. For example, TVA submitted an application for an early site permit for 2 small modular reactors at the Clinch River site in Oak Ridge, Tennessee in 2016. And then more recently, in 2019, the NRC issued early site permits supported by an EIS that evaluated impacts from construction and operation decommissioning of these 2 SMRs at this site. Marty, could you talk a little bit about how industry might plan to leverage the content of these previous early site permits for future reviews, either construction permit reviews, or operating license reviews, environmental reviews?
Yeah, I guess it is an issue that we are actively looking at, both NEI and several of our, I guess, affected members who, hold ESPs, and so it's very much still under consideration as to what that process, should look like. I just want to say, I think at the outset that, there is an ESP regulation, I think it's 5229, that says, you have to bring the information and data up to date at the time of renewal. And, I think the agency needs to think very carefully about what that really means and what level of effort should be required. I mean, an ESP is essentially, kind of an approval of a site, a banking of a site. It doesn't actually authorize any construction activities at the site. And so, when an applicant or licensee eventually wants to build a plant and pursues a CP or, a COL, combined operating license, presumably they're going to have to do, some reviews of the relevant data and potentially update it then. And so I think there is an ongoing dialogue between the industry and the NRC about, what a new and significant information analysis should look like for purposes of ESP, renewal. And again, my perspective on it is that really overall it should be more of an administrative or ministerial approval, much like an extension of a CP that's been done many times over the past. But all of that said, I think again, it's important for the applicant and the NRC to really try to leverage the prior environmental impact statement, incorporate by reference to the extent you can, especially given these page limits and time limits we have now have under NEPA. I think again it goes to the issue too, especially if it's the ESP is for a site which a plant is already operating. Take Grand Gulf, for example. Again, it would make sense to try to use all the available data. Licensees have very comprehensive REMPs or radiological environmental monitoring programs and other things. So to really make use of that. So I think again, in the end, the takeaway is encourage the NRC and applicants to be judicious in their new and significant information analyses. So we're not essentially recreating an environmental report.
Thanks, Marty. Ted, what are your perspectives on this?
Well, microphone here. Yeah, so while ESP included an evaluation of the construction impacts from all the activities associated with the building the SMRs, the activities related to the exemption request included only exemption support for the CRN1 reactor building. So where you have an existing EIS relevant to a later proposed action, agencies can employ tiering, and we think that might be of use here. Tiering is appropriate when an EIS or an EA for a narrower scope action follows a NEPA for a larger scope project. So because the activities related to the exemption requests are narrower in scope than activities evaluated for the CRN ESP, the staff implemented tiering for that into the EA. I think that could be a step in the right direction to making a simpler process. I'd like to throw in a note, kind of additional on the ESPs, just noting that there's been a perception that's been communicated in other RIC sessions elsewhere about environmental reviews being time consuming. And some of that data came from the Columbia report, which was referring to ESP data and reviews that were done in the early 2000s and 2010s. And so we went back and looked at that data and just to see where we were. And I just wanted to point out that, for those projects, the final EIS was published ahead of the SAFE review in 10 of the 14 instances. And of those where we led, it was ahead by an average of 2 years. In the 4 where the NEPA was lagging the safety, it lagged by an average of 3 months. And so while we've all made improvements in our processes since that time, just wanted to point out that we have, the perception that we are always the long pole in the tent, if you will, or lagging is not really supported by the data as we've looked at it. Now, more recently, just to kind of extend this thought a little bit, if I could modify the question a little bit, Chris, we've had some delays in the license renewal space because of some actions where the environmental reviews were either delayed or restarted, and the safety reviews were not changed, and so they got out of sync. And so for those, we've not been able to stay in sync with that. But as we've processed out of that and recovered and published the LR guides, we're now back in schedule and in sync with the safety reviews and staying either with them or slightly ahead of them as we've gotten back into our stride.
No, thanks, Ted. Marty, do you want to?
I was just going to say on the license renewal front, I think, no, you're right. I think over you look at the history of renewal, it was kind of a bathtub curve, where I think the staff drove down the review times. Maybe it might have been 3 or 4 years, down to 2 years, 18 months, and they kind of crept up again. But I think the NRC is definitely heading in the right direction in view of recent reviews. And then I just want to mention that the commission, I think through a commission action memorandum, has actually directed the staff, right, to achieve 18-month schedules, and I think set a cap on the number of staff hours, I believe. Is it 14,000 total? Which is a significant reduction compared to, I think it was 22,000 or some of the estimates we were seeing just 2-3 years ago. So I think that's very good progress. And just generally, I want to say, I'm not sure the whole NEPA narrative around NEPA is really fully caught up with present day circumstances. I think, the NRC is making very significant strides. And I think sometimes NEPA gets a very bad rap for reasons that are entirely unrelated to our industry. There's been notorious delays on whether it's pipeline or highway projects and just volumes of federal court litigation. So I think it's important to understand that.
No, thanks, Marty. So I want to just continue on that thought a little bit. So Ted, thanks for the thoughts, and Marty for the perspective. Nico or Lisa or Alicia, any thoughts on the timeliness of NRC's or the federal government's NEPA implementation of the NEPA process, the timeliness of our environmental reviews relative to reactor licensing or materials licensing? Any thoughts on that?
I guess from my perspective, I came from an operating plant. I was the licensing supervisor, and we would submit a change to something that would require NRC approval, and it would take a year, generally, to get approved. And then I come to our new nuclear side of the house, and we're aiming to license a whole brand-new plant, at least for construction, within 2 years. And those timelines seem out of sync to me because it's like the volume of information that has to be reviewed for a new plant would seem to be very much greater than a change to one aspect of a plant. So I know, and I applaud you for getting your license renewal metrics down to 18 months. That still seems a bit excessive to me, given that we have the guys and that we can aim to do a brand new plant in 2 years. So I would challenge NRC to even be bolder.
No, thanks for those perspectives. All right, we have I'll look to our production team, and we have another live poll. Hopefully you can pull that up. And it's actually has a connection to what we just talked about, which is the scheduled driver? Is it the safety review or the environmental review? And I think Ted alluded to the fact, I think the environmental gets a bad rap in general. There are some instances where the environmental review certainly lags, but I would submit our performance over the last couple of years has improved significantly, and we're not quite the lag that people might think we are when it comes to environmental reviews. All right. What do you perceive to be the most challenging part of modernizing the environmental review process? A, complexity and volume of applications. B, timeliness of consultations. C, assuring sufficient opportunities for public engagement and participation. And D, a changing, evolving environmental review landscape to include case law. And I can see that by majority vote, the most challenging part of modernizing our environmental review process is the complexity and volume of applications. I think that, adding my perspective, yes, for sure, the volume of applications is significant. For those of you who joined one of the plenaries yesterday, they talked about the rainbow chart, where you looked at the forecasted new and advanced reactors that are in the pipeline, either in pre-application or on our radar. It's significant. And not only will those have a safety review, but we'll also have the environmental review as well. And are we prepared from a resource and a process standpoint to be able to handle that volume of applications? So yeah, I would agree with the poll, and yes, that's probably going to be our biggest challenge moving forward. The others are challenges as well. There's a reason we put them in the poll. We do have an obligation per our one of the 3 pillars of our strategic plan is to inspire stakeholder confidence and to ensure that we give the appropriate level of opportunity for the public and externals to participate in our regulatory processes. It's very important. Timeliness of consultations. Consultation under NHPA and ESA is part of our NEPA process. We are a partner in those consultations, so we are beholden to a certain degree with the entities that we consult with. And that can raise some certain challenges in our environmental review, so we have to keep our eye on the ball on those. And then Marty probably is quite familiar with the changing case law, or the case law that he alluded to earlier in his remarks. We've seen unprecedented change in the environmental review landscape in the last couple years, and I foresee we will continue to see that pace of change moving forward. So a challenge for us is to keep track of that stuff. So thank you all very much for those responses, and let's go to our last question for the. Oh no, I think I have one more. A question this is open to all our panelists, and again, it's on public engagement. What are our current approaches for ensuring that all groups have equal access to interact with the NRC and DOE and our environmental review process? What should we do more, less of? What should industry's role be in effective stakeholder engagement? And some of you alluded to, industry can also reach out to external stakeholders interested in a particular project. So anyone like to kind of address the public engagement, stakeholder engagement aspect?
I can start us off.
Lisa. Yeah, okay. You're one of our partners. You experience the same thing
Yes.
that we do in your environmental review. So yeah, feel free.
So at DOE, we, particularly within LPO, we always look to make sure that we understand who our audience is and who we are trying to reach. That's kind of in the forefront of our minds as we're starting out with our NEPA reviews and our environmental reviews to interface and, involve for public involvement and public engagement. 2 items I'd like to bring up that I think are success stories, what we do at DOE and within LPO. One is our website. It is mobile enabled. We understand that a lot of folks have process their information through cell phones or through iPads. And so we try to ensure that our websites are mobile enabled as well as our documents, so that when you open up an EA or an EIS that's on our website, the LPO website or the NEPA compliance website, you can view those documents readily, and you're not necessarily getting things that are skewed on the page and pretty much unreadable, where you need a PC or a laptop to be able to review that information. The other example I would bring up, which I think is a success that we've done at DOE and also specifically within LPO, is for our public meetings. We have, we will create a presentation where we record it. In addition, we will record the public meetings and post them to our website, so that, maybe people who are not able to attend our public meetings or want to just kind of see what's going on with our project, when they look on the project webpage, they can review that information that was presented at the public meeting, actually see the presentation, the video, and then provide their comments or provide additional information that they think is necessary. But we provide that flexibility for members of the public to try to help to widen our net in terms of public engagement.
Thanks, Alicia. Anyone else like to comment on that? Go ahead, Marty.
Happy to just quickly give, I guess, an industry perspective. I mean, I think that to us, the public engagement, it's a no-brainer. It's vitally important. I think, all of our, or many or most of our members, have employees who are devoted specifically to that role, whether that be large utilities who have very well-entrenched community engagement programs and programs in place to benefit the communities in which they operate. But I think it's been really important too for advanced reactor developers, again, like TerraPower or Kairos. I know they were very aggressive in reaching out to their communities and trying to build that public confidence in and acceptance of their projects. It's important. You just got to look at the Consolidated Interim Storage Facility facilities in Texas and New Mexico. And I think that speaks volumes of how important it is to have buy-in from the local communities and the state governments themselves. That's now led to litigation that's before the U.S. Supreme Court, argued last week, actually. So, but at NEI, I just want to say, we did a lot of work during the Biden administration on the environmental justice front, developed some EJ principles and an EJ program options document. A heavy component of that document is stakeholder engagement. And, I did want to mention too, and I'll give a shout out to my colleague, Katie Austin. We just recently formed a new working group, the Advancing Collaboration, Community Engagement, and Public Trust, or ACCEPT group. It's called ACCEPT. So that's very much in the formative stages. We're just getting underway, but, it's going to be an effort to coordinate industry work on this front, possibly do some benchmarking of best practices when it comes to community engagement. So in a nutshell, very important. And the last thing I'll say is, when we were doing our EJ work, we did comment heavily on the NRC's stakeholder engagement process and, identified a lot of positive aspects, had some constructive recommendations too, but I think the NRC is doing a good job, so.
Thanks, Marty. All right, I want to spend a few minutes because we do have some questions from our audience, and this one I'm going to offer up to Ted. I'm not going to let you off the hook that easily, Ted. So, and it's fairly straightforward.
I'd expect nothing less, Chris.
Yeah. How much benefit is actually realized from doing an EA versus an EIS? Where do we see the benefits, and is there any quantification of what the benefit looks like?
That's a great question. And it's not as simple as you might think, because you need to keep in mind as you're thinking about this, that the way we're doing EISs, we are streamlining as well. And so the answer today is not going to be the same answer as it might be a month from now, 2 months, 6 months from now, right? As we continue to streamline the way we're looking at EISs and do that process faster, then we could see those timelines merge. The other thing that I think you need to consider as we look at the EA versus EIS question is, as I mentioned in the beginning, how it aligns with the safety review timing. If we can be more predictable and effective and consistent with the safety schedule and still do an EIS, where the alternative would be to take an EA that might have risk of a finding that is not a FONSI and then having to start an EIS. It might be a preferable approach. So there are some nuances to this question. Where we are now is we're seeing some good savings, and it will, in the short term, I think, see some good progress in getting under that 18-month license renewal schedule. Right? EAs really enable you to push that envelope more. But going forward, we need to think about this question carefully.
Oh, thanks, Ted. I have a question here for Lisa, and it's regarding brownfields, right? There was some good information you shared on brownfields, and the question is regarding the interest or willingness of a utility to want to declare an area as a brownfield to begin with, and would they want that? Would they want to declare an area brownfield in order to reap the benefits, or is there risk involved?
I am not probably that as up on that specific topic as I should be. So I don't really know all the risks associated with calling something brown fields. We call our site where we're planning to put the SMR project a brownfields, even though it just has some partially constructed reactors from the 70s. It was highly disturbed. It's been mostly remediated, but it's not a greenfield site. So I don't know if you have the info on the brownfield risks.
Yeah, I guess I would mention, we work closely with Epry Electric Power Research Institute, and they've issued they've got a siting evaluation guide that you're probably familiar with, but recently issued kind of another version of that's specific to siting reactors at brownfield sites. So I think there's a lot of good guidance there. I guess one area where I have insights is if you're dealing with retired or soon to retired coal plants, because the legacy contamination in terms of the coal combustion residuals or coal ash can be significant. The liability there. So I think that's one issue that you have to look at very closely as to whether you want to site your reactor on that site or maybe just near it. But the liability considerations are significant in the EPA and the state regulatory schemes for managing. Ultimately, disposition coal ash are very, very complex. So,
Indeed.
Yeah,
indeed.
yeah.
Very good. Thanks. All right. Well, I think we have time for one more question, and I'm going to look to my federal partner, Alicia. How can the DOE and the NRC increase cooperation to be more efficient in the overall environmental reviews that we conduct as partners?
Well, that's a bit of a tricky question because, and the reason I say that is because I work specifically in the Loan Programs Office. So throughout DOE, the various departmental elements typically have their own MOUs or their specific MOUs with the NRC. For example, I do know that the TerraPower project, they have an MOU, the Office of Clean and Energy Demonstration, they have an MOU with the NRC, as well as the Office of Nuclear Energy. They have an MOU with the NRC for nuclear innovation and advanced reactor projects. So that's why I say that's a little tricky. I can tell you that from the LPO, we are open. That's why we have an MOU with the NRC, is because we're open to any future nuclear energy projects that may come to the LPO for federal financing. We are hoping and looking to make sure that we work with the NRC, whether that be reactors as well as projects within NMSS. So, yeah.
Oh, it's good. Thanks. And I think we do have time for one more. I'm going to look to, let's see, who can I, so this actually is a question for me. I'm not off the hook. Well, it's for me and Ted. It's an NRC question. And, I think it kind of comes full circle to, what does all this mean when it comes to, we have 22 efficiency actions that we've identified in our report to Congress. We have a new external NRC website. Hopefully you all visit. It talks about the NRC's environmental blueprint, the title for our session here. On that website, we list the 22 items plus a few more. I think last count we had 28 efficiency initiatives that are documented on that website that we're all currently being pursued at the moment. We are pending direction from the commission on a commission paper on implementing FRA that we're waiting for commission direction on that one, and looking forward to receiving that. So there's a lot in the works. We are looking to, as I mentioned earlier, looking at the return on investment, the biggest bang for the buck. Which ones can we implement and prioritize sooner? We looked at the implementation of environmental assessments versus environmental impact statements, streamlining the actual technical review, risk-inform the technical reviews to make sure we're expending the appropriate level of effort in each particular resource area. So as Ted kind of alluded to, there are complex EAs that may be resource intensive, but there's also streamlined EISs that may be less resource intensive. And the gap between those two might be smaller than what folks might think. So we're not just looking at changing the way we document our reviews, but also how the reviews, what's the most efficient. Nico talked about CADXs, definitely the most streamlined version you could talk about, because that's on the order, level of effort on the order of a couple hours, so to speak. So all this kind of fits into the mix of how we are being more streamlined and more efficient and timely. Why does this question come up? Because it's, where is the schedule driver for the NRC's licensing decision? And I can attest, our goal is for the environmental reviews to be as streamlined as possible, such that we are enabling, per our new mission statement, we are enabling the advancement of nuclear energy and nuclear materials. Ted, did you want to comment on how we are supporting the NRC's mission and becoming more streamlined and efficient, timely and predictable in our environmental reviews to kind of close us out?
Well, I suppose I can, since you're asking me to. Yeah, so just to point out that, again, we have as you mentioned, the blueprint where we've got 28 efficiencies, and we're looking at how we're going to be measuring the progress we make in those as part of the reporting requirements under the ADVANCE Act, and thinking about how do we identify which efficiencies are worth the investment, which ones are proving to really provide savings in efficiency, but also maintaining that predictability in the result. And as we work through that, how we're going to track those and report those and make determinations of what efficiencies we lean into even further than we are, and which ones we sunset because they're not proving worth the effort.
Very good. Thanks, Ted. All right, in the last couple minutes, I would like to thank you all for attending. A big shout out to Leah Parks, my session coordinator. Raise your hand, Leah. And also Brian Newell, who helped Leah in some of the early stages. And then a big shout out. Yeah, thanks. Well done, Brian. And then, of course, our panelists, Marty, Lisa, Nico, Alicia, Ted, thank you very much for volunteering, some with a little bit arm twisting, but volunteering to be our panelists today and answering all the questions that we posed to them. Very much appreciate your participation today. Thank you very much. Thanks, everybody.